Everybody's doing this wrong. I even just ChatGPT'd it and it's hilarious. ChatGPT says you need to do an asset purchase and not a stock purchase, particularly for your first deal. That's absolutely incorrect. And obviously, for years, I've had to deal with this with clients coming to me saying, Joe, I'm supposed to do an asset purchase. I already agreed with the seller to do an asset purchase. Or, my teacher told me to do an asset purchase, or Google said to do an asset purchase. I've been dealing with this for years. It's just not how it works. And I get it. I'm not trying to be offensive to a lot of people I know have told people to do asset purchases. It is the prevailing wisdom. It just happens to be wrong. And it happens to be wrong for legal nuance reasons. So, people who aren't lawyers wouldn't really understand, or, they weren't thinking all about these reasons. So I'm going to go through the reasons why you're never supposed to do an asset sale for your first deal, unless frankly it's a junk deal, or the seller's bending you over. The seller won't let you do a deal that's not an asset purchase. So here's the reasons why. So first of all, everybody thinks, and this is what obviously the first thing everybody says, go Google it. Everybody thinks that when you do an asset purchase, you can just acquire some of the assets and liabilities, so parts of the business, and leave out all these unknown liabilities, leave out all the problems, the unknown problems. It sounds kind of magical, but the law is always very practical, not magical. So what's going on here is you have an asset purchase agreement. It always says in those assets, I have them, my forms, the asset purchase agreement says in there, okay, I'm only buying these assets, and certain liabilities usually says something like only liabilities tied to the contracts I'm acquiring. And so the asset purchase agreement says you're not acquiring liabilities. People think you're in the clear. Again, that's not how it works. This is why most of the states have a law called the successor liability law. And again, understand that the law is very practical. The law isn't going to just let business people transfer assets and not pay off vendors and people who are owed money. That's obvious. Obviously, the law isn't going to let you do that. Always kind of try to think practical when you're trying to figure out what the law is actually going to do. And the successor liability law says just that. If you buy a business and you're still continuing that business, then no matter what, even though your contract said otherwise, you have to pay their liabilities. And I've had clients try to do this in the past, and they still got sued by vendors who weren't paid of the seller, even though they only did an asset purchase. And that brings us to point number 2. You can get sued anyways. So you might think to yourself, well, if somebody tries to sue me, I'll just tell them, look, I don't own that liability. Look at my contract. That entity is not me. So that was, Hardware Warehouse of Oregon, and I am the School Side Hardware Warehouse Inc. So I'm a different business, and so they can't sue me. Any unpaid vendor, for example, so like somebody who might have been supplying inventory to the Hardware Warehouse of Oregon, those vendors can't come after me. I'm a different business. I just happen to acquire some of that entity. My entity just happened to acquire some of that entity's, contracts and assets and inventory and their lease and their business. And that's also not how it works. So point number 2, you're going to get sued anyways. Any smart lawyer on the other side is just going to name you in the lawsuit. And you might say to me, Joe, well, I'm just going to get that lawsuit dismissed because that's not me. And let me tell you, that's not how it works. You're not going to get that lawsuit dismissed. And so that's point number 1. That's point number 2. Point number 3, why not to do an asset deal? Everybody also says this when they say, hey, I need to do for the tax treatment. I need to do an asset purchase because it has a step up in basis, this great tax treatment. The thing about it is what you're supposed to do, and we'll kind of end on what you're supposed to do. You're supposed to do a stock purchase with asset sale tax treatment. So you can do that. Yeah, you can do that. That's what you're supposed to do. And then there's a special version of that, which we actually recommend, which I'll tell you at the end. So that's point number 3. It's not about the tax treatment. And always make sure you're putting that in your offer up front. Obviously, we prepare the offers for our clients, and I don't recommend people go willy-nilly try to learn how to write an offer because you're going to get it wrong. But in your offer, you need to say that in there. We're pricing this acquisition as a stock purchase with asset purchase tax treatment. And then to do that, there's more legalese, which I'm not going to get into here. And the 4th and final reason why you should never do an asset purchase is because, and I don't know, this one's probably the most inconvenient of them all. I mean, those three ones are pretty, as you can tell, they're pretty slam dunk arguments as to why, you should do a stock purchase and not an asset purchase, or why an asset purchase doesn't have the value you thought it had. But this one really puts the icing on the cake, and there's other reasons as well. So I almost forgot to mention this one, but I'll leave it at this one for the fourth and final reason is, so when you do an asset purchase of a business, you essentially have to rebuild the bit, which kind of sounds crazy because you have to rebuild the business. So it sounds crazy because what you're doing is buying a business, and your job is not to mess with the business so your cash flow doesn't get messed with. But when you do an asset purchase, you literally have to rebuild the business on the day you acquire it, which is going to be the busiest day of your year. And so the people who end up doing that just end up having so much more work, they can't even focus on transitioning the business because they have to rebuild the business. Now, what do I mean when I say rebuild the business? I mean, okay, well, you had to set up a new entity, right? So now you have to get insurance again for the new entity. Now you have to get any permits or licenses again for your new entity. In some cases, they can be transferred over. In the vast majority of cases, they cannot be. And that could be a very arduous process. You have to get all new contracts. So I'm thinking through there's a ton of different reasons, thinking through all the little reasons. And you have to get new contracts. So new contracts with all the vendors. What do you mean, Joe? Didn't I just buy all the contracts? Yeah, but it's not really how it works. The employees now are going to be your employees, and a lot of these small businesses don't even have employee contracts, for example. So now you basically have to rehire all of your employees. Talk about an opportunity to lose value. Having to do that instead of just smoothly letting them all continue their job and not have to do that. You have to assign the leases. This is a really annoying one. I've had deals die before because the landlords of the properties that the businesses were operating out of, again, the business being acquired has some leases. Say it's a retail goods shop with a few different locations in a city. And for the buyer to buy that business as an asset purchase, you have to transfer. Assign means it's a legal word for transfer. You have to transfer those leases to the buyer's new business entity. And to do that, you need to get the written consent of the landlord. And that means you get to have the fun of paying me to negotiate with multiple landlords new leases. Let me tell you, they don't make it easy. I have had some of them make it easy, but I've had some of them just say no. Or, hey, you're going to have to put up a huge deposit, or no, you don't qualify. And you might say, Joe, that's kind of crazy. Those landlords, just the lease part of the business, because the business is obviously much bigger than that. Landlords killed the deal and made it so that sellers couldn't sell their businesses. Sorry, this thing's shaking. Yeah, that's right. That's exactly what has happened, and it happens to people. And frankly, it's ridiculous, and it could be avoided if you just didn't do an asset purchase. Now, in stock purchases, sometimes there's more nuance here. Always in the law, right? There's always more nuances, but that's generally it. So, okay, those are 4 points why never to do an asset purchase. And the structure I said I'd give you at the end what structure we recommend to do. And the best structure you could do is an F reorganization, it's called. It's very complicated. You can't do it yourself. It's a very legalese thing. I don't recommend you try to wrap your head all around all these complex concepts. That's why you hire an attorney. And if you're going to buy your first business, come over to our law firm and come work with us. You can book a call with us at Principe.com.